number 81, 340673 LLC versus Seneca Insurance. Just give council a moment to move away.
Good afternoon.
Good afternoon.
I'd like to reserve 2 minutes for rebuttal, if I could.
2 minutes.
Members of the court, may it please the court. Our case is premised on 2 basic points. Point number 1, pursuant to CPLR 3025C, the trial court wrongly allowed an amendment to a breach of contract claim during trial to add a reformation claim. The second point is, in any event, that claim was untimely as a matter of law when it was made. And when I went through the 2,781 pages of materials, 7 volumes, I realized there's only 2 documents that we need to consider what the right answer to this case is. The original complaint and this court's decision in 1976 in SCM.
But then, weren't the parties very clear from the beginning that the dispute all turned on the interpretation of the PSC? And the dispute was whether or not that PSC barred the damages?
I think that's absolutely right, Your Honor, and that's the problem. It concerned the application of the PSC, not whether the PSC was in the policy. And this court's decision in SCM makes clear that those are 2 distinct occurrences and transactions, and they have to be.
So SCM relates, I mean, you said there's 2 points here.
Yes, Your Honor.
SCM seems to me, but correct me if I'm wrong or misunderstanding you, to your second point, having to do with relation back, it doesn't have anything to do with your 3025 point, is that right?
It doesn't, other than to inform what is prejudicial.
So let me understand what your 3025 argument is, because my understanding is leave to amend can be freely granted, should be freely granted, can be granted even, you can conform the proof to the pleading to proof even after trial's over. So you have an uphill battle there, I think.
That's correct, Your Honor, but it is not unbridled.
Right.
And in this instance, that's exactly what happened. And again, it's informed by SCM, and I understand SCM is a 203F case, and I'll address that when I talk about relationship back. But if one starts with the presumption that the factual predicate necessary for a reformation case is entirely different than the factual predicate necessary for a breach of contract case, which is what SCM says.
What do you mean by factual
Sure.
predicate?
The only facts that are important and necessary for a reformation case are everything that took place prior to the contract. Once that contract is entered into,
Well, there could be evidence that relates to that issue that wasn't created until after the formation of the contract, no?
Your Honor, not unless it pertains to discussions and events that took place before the Reformation, right?
But those could have been memorialized after.
Fair enough, but we're still talking about events that took place prior to the contract being formed.
Just want to be clear.
Anything prior to the contract being formed is relevant when it comes to Reformation.
And is that why it matters here what was in the original complaint?
It does, Your Honor, because the only thing in the original complaint, and I could recite it to you paragraph by paragraph, there are only 11 paragraphs. We breached the contract because we didn't pay them. That's it. It talked about the property, it talked about the fire, it talked about the policy, it said they satisfied the conditions, the amount of money at issue, and we
But
breached.
it does not discuss what happened before.
Not at all. And that's the important point here. In fact,
Is it, counsel, is that really the important point under 203F? Because
it-
it seems to me under 203D, which is counterclaim statute, you're looking at whether or not on an equitable kind of reduction of plaintiff's damages theory, whether or not it arose from the same transaction. And that's a very tight test, right? And that gets you even beyond a barred claim you can still use almost as an offset, but really as recoupment. Under 203F, you don't have a test that it arises from the same transaction or series of transactions in the complaint. It's whether or not the complaint as a whole, I believe, gives notice of the transactions or series of transactions you want to now add.
Well,
And that's a very different standard because those statutes do very different
Well,
work.
Your Honor, I think what 203F is intended to do is to say, if you want to take a transaction, an amended issue, a claim, after the fact, you have to show that that amended claim arose from the same occurrence and transaction as the original claim. That's the first point. And that we were on notice of it in the original
No,
plea.
that's not what the statute says. The statute says that the original pleading gives notice of the transactions, occurrence, or series of transactions that you want to now prove in your amended completing. That's very different than arises from the transactions or series of transactions that are already in the complaint.
I'm not so sure I see a significant distinction, Your Honor, if I could.
For D, which is counterclaim, that provision we're talking about only applies if the claim you want to interpose, the counterclaim, was time barred at the time you sued me, right? And it's only for the equitable purpose of me reducing your damages. So this test is very tight. It's whether or not that claim arises from the transaction you sued me over, or series of transactions. And then I can use it to reduce, even though my claim is out of time. Under F, you're amending your own complaint. So it's notice to me. But it's notice from your entire complaint of the transactions you now want to add. And that's very different.
Well, and I submit that's exactly what happened here and why it's wrong.
Well, and I agree, that's the question here, but it's not SCH.
Well, in this, it's SCM. It is SCM. Because in SCM, SCH, whatever the verbs, it is SCM. Yeah. Let me just, if I could, articulate why. What we had happen here was a case for 8 years of breach of contract. And if you look at every step along the way, whether it be the pleading, whether it be discovery, whether it be motions for summary judgment, including the order on the motion for summary judgment, where the judge said two things go to trial. Was the PSE complied with? And was there waiver, post-policy waiver, our behavior that allows one to conclude that we waived the PSE? Those are the two things that went to trial.
But isn't it the complaint we're looking at? It's
Sure.
In terms of notice, not in terms of prejudice. I
So
agree.
let me walk through the complaint. Paragraphs 1 through 3, the parties. Paragraph 4, the property. Paragraph 5, the policy. Paragraph 6 was just the fire. Paragraph 7 was our involvement and basically that we were advised of the claim, we didn't pay the claim.
And I agree with you that you're describing the complaint, but the issue, and I'm saying which way it comes out, but the issue then is, do those paragraphs give notice of the transaction, which is the pre-signing conduct?
Right, and SCM speaks to that, because what the complaint had was a breach of contract claim only. And what SCM says is when you want to add an amended complaint for reformation.
No, you want to add you want a counterclaim. You want to add SEM as a counterclaim.
There's no distinction here, Your Honor, between a
The language
counterclaim.
is completely different. The language of the two provisions is completely different.
Your Honor, if one starts with what is the statute of limitations for a reformation claim? It starts in April 1st, 2009 in our case, right, which is when the policy was issued. That's when the mistake should have been known or was known, 2009. 6 years later, 213.6, CPLR 213.6, it expires, April 1st, 2015. The only way that case or claim is revived in 2019, when it's amended, is through 203F. The only way. And the only way that happens is if that claim, that reformation claim, we had notice of that occurrence or transaction in the original complaint,
Not notice of the claim, right?
of the occurrence and transaction, the factual predicate,
You had notice of the transactions they were going to base the claim on.
Which
That's
wa-
203F.
which was the breach of contract.
203D is, it arises, the counterclaim arises from the transactions you put in the complaint. So it's different.
They put in the complaint, but we're the defendant. But 203F is what governs here, because the only way you make this claim proper, timely.
Agree. I agree with you. I'm just saying that 203D is a very different test, and the case that I keep mislabeling is concerned with 203D as an equitable reduction of plaintiff's damages under the specific language of 203D. And I'm not saying that's a win or lose issue. I'm just saying that I think the approach under 203F is very different.
I think, Your Honor, the outcome is the same. The outcome
No, I
is the same.
understand that, your position, but I think your analysis has to be different.
Because if we don't have this outcome, if this outcome is remaining as it is, every contract, every case where someone asserts breach of contract and only breach of contract, every attorney in every court has to prepare a case that they're not told is relevant.
Doesn't that depend on the complaint and how much information they put in it?
Presupposes that
Well, they
they
may
haven't
have
been
to, or
told
they
it's
may
relevant.
not have
That's
to.
exactly right. But here, that's not an issue, because
Thank
it
you,
wasn't
counsel.
pled. Thank you, Your Honor.
Your Honors, may it please the Court, my name is Dennis D'Antonio. I represented the respondent at trial, and I'm also representing the respondent today. The case law that's emanated out of this court there's a plethora of cases that speak very clearly to the fact that leave is freely granted to amend a pleading at any time during, before, or after a case has been
Well,
tried.
counsel, isn't it really true that you litigated the case as the PSC was part of the contract, but they knew that you were out, their client, excuse me, not you, of course, was out of compliance with the PSC, and therefore you shouldn't be bound by
Well-
the PSC. That is the way the case was litigated from day one. And so if you want to amend, their argument is, we're completely prejudiced. This comes out of the blue. How can it be? What we've been arguing is whether or not we waived it by the fact that, yes, we had an inspection, we know the sprinklers are not working, or weren't there, whatever it was, and that becomes the debate, not whether or not the parties had a meeting of the minds on that PSE.
Your Honor, that's correct. I would refer, Your Honor, to your decision in the Kimzo apartment case versus Gandhi, where you and this is consistent with all of the other Court of Appeals decisions, except for the one decision they rely upon, which I think is distinguishable for reasons I'll get to. But you wrote a decision that's consistent with every other decision, and you said that leave is freely granted absent prejudice, and this favorable treatment even applies in the event that the amendment substantially alters the theory of the case. And every one of these cases where there's a motion made
There's a difference between altering the theory of the case and proceeding on a theory that makes the alternate theory implausible.
Well, Judge, then let's look at it.
Implausible. Your whole position was, we have a contract, they waive the provision that they're relying on. The position was never, yes, we have a contract, they breached the contract, which I think could be a reading of the complaint apropos of Judge Garcia's questioning, but that's not how you ever litigated the case.
Well, Your Honor, the cases are, this issue that's before this court is to be decided sui generis. It's in the Court of Appeals decisions. And there's broad latitude and discretion left to the trial court and the appellate division to rule on whether or not a pleading should be amended at trial. The
Doesn't that
facts,
discretion have to be subject to 203F?
yes.
And there has to be notice of the transactions or occurrences that give rise.
Well, look at the facts of this case, Judge. They had an underwriting file that they did not produce.
But counsel, let me ask Judge Cantaro's question a different way. What in your complaint gives them notice that you're going to base a claim on pre-contract conduct?
I'm not basing it on pre-contract conduct at the time I'm pleading, because I don't know
That's the
what I
problem.
subsequently... Well, it's not really, Judge, because if they had produced the underwriting file in 2011,
But
which is...
that's a different argument. Let's stay with your complaint as it's written. I understand your arguments with respect to their conduct later, but your complaint is written. What in that complaint gives them notice that you may file a claim based on conduct before the contract was signed?
The complaint does not plead reformation. There was no basis at that time.
I understand, and it doesn't have to. It just has to give them notice that you might add that claim.
Judge,
So, and that claim is based on very different conduct. So what in the complaint, and it can do this, But to your adversary's point, what in your original complaint satisfies 203F and gives them notice of the transactions that you're going to
The
add?
appellate division and Judge Crane both concluded that the allegations in the complaint alleging that there was coverage under the policy and that there was a breach of contract was sufficient to have initiated the lawsuit. They did not raise the protective safeguard endorsement until the answer was served, and that came up in the fourth affirmative defense. We were free to litigate that issue at that point going forward without relating back to the original pleadings in the case.
But, sir, your whole, and you'll correct me if I'm wrong, but the theory, as I understood it from the plaintiff, is there's a contract, they were supposed to pay me for this fire damage, they didn't, and no, I never, right, they have to pay me. Again, sort of on this line of questioning, how are they to know that your real argument is, we had a contract, you were supposed to pay me, and that one little provision that allows you not to pay me, I never negotiated. I mean, of course you knew that in advance. There's meetings of the minds, and your client is one of the minds.
Yeah, but Your Honor...
Your client must know and admitted, well, I just didn't read it, I didn't know, you know.
Judge, but under the facts of this case, which are really relevant to the sui generis analysis, the client didn't know anything. They purchased a policy. They admitted they didn't read it when they got it. All he said was he had never requested
But
sprinkler
wouldn't
coverage.
Malik, his knowledge be imputed to the plaintiffs?
Well, just same way, Judge, that the knowledge of Mueller, the underwriter, who testified that the underwriting file doesn't have the documents necessary for this to have been part of the policy.
But Malik was there.
But he's-
And
well-
Malik is there, and he knows whether or not it was his intent for the PSE to be included.
That's not
So
mutual-
that's information that was available at the time the complaint was
Judge, that's not mutual mistake. That's just him not understanding that the policy was written that way. And don't forget what happened here. We asked for the underwriting file. Had they produced it in 2011, then I would have seen what I didn't see until 2016 and 17, and that is that the file didn't support the inclusion of the PSE.
Do you have an equitable estoppel argument here?
Sorry?
Do you have an equitable estoppel?
Yes, I had a waiver argument that since they knew there were no sprinkler systems, that the PSE requirement was waived, a voluntary relinquishment of a known right, and that they should be stopped from relying upon the PSE because they knew that there were no sprinklers. They knew that when they bound coverage. They knew that after they bound coverage. They never canceled the policy. And if you read Judge Crane's courtroom, the motion was made to the court at trial. It was very clear that she
But with
said...
respect to equitable estoppel, if plaintiff had that information at the time that they formed their complaint, or they should have
We
known
didn't.
that they should investigate.
But we didn't.
Malik?
We didn't have that. That came out of the insurance company file. They didn't produce that until 2016. When I got that file 5 years into...
I think if I'm understanding this argument in response to the judge, you're basically saying, well, I didn't have the smoking gun, I didn't have something in their file that would assist me in my argument, but you certainly had the argument.
Judge, this court should be troubled by the fact that they didn't produce the file for almost 5 years until the statute of
We
limitations...
may
Counsel,
very
didn't-
well be troubled, but that's a different question from this.
But, Your Honor, that being the case, if they've... I mean, there's case law out of this court. They can't benefit by their own misdeeds. If they've actively failed to produce the underwriting
They
file that...
offered the document, did they not? At some point, they offered the document that you're talking about?
I didn't get it until 2016, and when it was produced to us, they represented it as a complete file. When I deposed Mueller in 2017, it was represented as a complete file. There was nothing in the file that said it
It's
wasn't...
out of the blue to you. In the
Sorry?
same, it's out of the blue to you in the same way this argument to them is out of the blue, that somehow the client
Well, Judge,
never
but-
intended and understood that there would be no such PSE requirement?
Judge, they knew it was issued in error. That's what their underwriter said. That's what their files showed.
I don't know that that's what the underwriter
Well,
said.
I think it is what she said. She said in order for the PSE to have been part of the policy, you needed 2 documents that were not in the policy that was produced to me. So how, when they produced the underwriting file, representing it to
But
be...
didn't you argue that there was an oral contract?
No.
Wasn't there a disclaimer letter that you got in
Yeah,
2011?
they denied liability based on the
So
PSE.
wouldn't that give you a clue that you could plead then?
Reformation? I had no basis for mutual mistake. I litigate insurance cases all the time. Insurers have policies that have exclusions that we don't feel should be applicable, but they're part of
But
the
you're
contract.
pleading as if the PSE was valid.
We believed it was valid until we got to the underwriter, who admitted for the first time on the witness stand that they falsely represented it was a complete file.
I guess
It
this is
wasn't.
my difficulty. How could you, if the testimony of Malik is to be credited, how could you believe it's valid? His whole
Well,
point is there was no meeting of the minds.
Well, Your Honor, Mr. Malik testified that he didn't see the policy, he didn't know what was in the policy, he didn't know anything about it until afterwards. It's all done through a
All right, so if
broker.
I'm understanding you, then the position is that at the time the complaint was filed, there's, what was understood to be the contract didn't have a PSE in it?
No, we saw the PSC, we thought it was a valid part of the contract. It had been there when the policy was issued.
And Mr. Malik didn't say at that point, I never bought a sprinkler policy. This was supposed to be a non-sprinkler policy.
Well, the truth of the matter is he didn't, but even if he had, it wouldn't have made a difference. I've tried, if the carrier issues the policy with that endorsement, and we don't say anything about it until after a
It does make a difference,
loss.
because that would have enabled you to plead reformation right at the outset of the action.
I had no facts for reformation because I thought that the carrier, as is its right, could put in a PSE clause, which they can do, whether Malik wanted it or not, and the burden is on Malik to read the policy, and if it's in error, raise it. That never happened, so I viewed it as being bound by the PSE, and what we argued in our case and what we litigated, and it's basically the same facts, that there was a waiver, because they issued the policy with the PSE, they knew there was no sprinkler, and they kept the premium and kept the policy in effect. At trial, there was an admission for the first time that it shouldn't have been there. It then went to the jury, and the jury concluded, based on a clear and convincing standard, that it shouldn't have been there, and I didn't know about it because they engaged in a dilatory tactic, withholding the evidence for 4.5 or 5 years, and now they're claiming foul because it wasn't raised until late in the game. But they knew all along what was in their underwriting file and what wasn't in their underwriting file. I was the one who was surprised at trial, and to set this verdict aside, it would be a gross miscarriage of justice. I mean, this was not intended to be there. It's been admitted to. The jury found that by clear and convincing evidence. And I think, Your Honor, that if you're looking at it from a sui generis standpoint, you have to give credit to the fact that they hid the evidence from us. I litigate insurance coverage cases. That underwriting file is what tells me what my case is about. 5 years went by. They didn't produce it. They waited until the statute of limitations actually had already expired
we've got
by the
that,
time
but-
I got that.
If I understand your point here correctly, it's that until you got the discovery, at most, all you thought was this is a unilateral mistake. It was when you got the discovery, you realized this is a mutual mistake.
Well, not immediately, but yes, Your Honor, that's the argument. It's a unilateral mistake. If my client didn't expect
with the
it, it gives
contract.
me no relief. I argue waiver and estoppel. I didn't know it was mutual until, and I was trying a waiver and estoppel case. That was my opening statement. I didn't know they did it in error until on the witness stand for the very first time they disclosed that there would the documents that needed to be in the underwriting file for the PSC to be part of the policy didn't exist. And there's an implied
But if I'm
covenant of...
understanding your argument now in response to Judge Wilson...
sorry, Judge?
If I'm understanding what you're saying now in response to Judge Wilson, as you continue with this, you realized it's a mutual mistake because there's a document missing in the file.
I realized it was a mutual mistake when the witness testified for the first time that file that we gave you, that underwriting file, doesn't have the documents in it.
That doesn't mean that there was a mutual mistake.
That
That
doesn't-
means there's a paper missing from a file.
No, to the contrary, Judge. I mean, she testified that for the PSE to have existed in the policy, there had to be 2 documents, a rate form and one other document I don't recall. They produced that file, 805 pages. It didn't have either. They were missing. They weren't there. And I said to her, well, if they're not there and they're required in order for the PSE to be part of the policy, is the PSE in the file, is the PSE made part of the policy in error? And she said, yes. It was never bargained for. It was never negotiated. We paid a higher premium because there were no sprinklers in this building.
Thank you, counsel. Thank you.
There was no admission at trial. This underwriting file is not relevant to a breach of contract case. That's part of the issue here. They were not banging on our door in 2013 and 14 and 15 saying, give us the file, at all. It wasn't relevant in this case. And they had it in 2016. And they had that same witness in a deposition chair in 2016. They never asked her a question about reformation or what happened with the contract or the PSC at all. This was a theory that was created at trial.
Counsel, the underwriter's testimony was kind of a bombshell at trial when she admitted that this very well may not have supposed to have been a sprinkler policy.
So it
right?
was, we have to remember, she's not the underwriter. That's part of the problem. She's a supervisor. The actual underwriter, he became mentally incompetent in 2013. He couldn't testify. Also part of the problem. If this was a reformation case in 2011, we talk to that underwriter. We take the deposition of Mr. Malik very differently. We bring the brokers in. We have a whole bunch of things that happen. But that's not relevant because it's not relevant at the time.
Well, to plaintiffs' complaint about the discovery process, if they had had the underwriting file, which they did request, they might have stumbled upon the mutual mistake that became very apparent
But even
at
if
trial.
that's right, first, it still doesn't take away from the fact that for purposes of this analysis, we look to what the allegations in the complaint were for pleading purposes. But even if that's right, they had the underwriting file in 16. They had that witness on the stand in 16. They could have asked her anything they wanted. They never did. Mr. Malik, Your Honor, you made a great point. He knew, if we take him for his word, the day they filed this complaint, that PSC should not have been in that policy. That's his position. I actually heard counsel say, we presumed, we took it that was a valid provision in the policy. If that's the case when they filed that complaint, then there is no mutual mistake here. There is no reformation claim. It was simply something that good lawyers figure out on the fly during trial. It's a violation of the rules, it's not fair, and this is the exact reason why we have these types of rules.
But doesn't this part of your argument, and maybe goes back to a point you made very early on, really go to the 30-25 decision? Because that, to me, seems like timing, when you should have made this, should we allow this now to conform to proof that comes out at trial? Whereas once that's granted, we go off into 203F land.
I think it could be both, Your Honor. I mean, I think that there are both issues here, right? How are we going to try a reformation case that is premised on facts that are never before anyone? No one has disclosed, there's no discovery on it, no nothing, on the day of trial. Wildly prejudicial. Second point, if you're going to talk about reformation and you're going to talk about a breach of contract, two entirely different occurrences and transactions. They can't be treated similarly. They don't relate to each
Our
other.
review standard for 3025 grant is abuse of discretion, right?
That's correct, Your Honor.
All right, thank you, counsel.
It was a privilege. Thank you.